Today's presentation is titled Litigation and Claims Trends for the Life Sciences Industry, the 2016 Year in Review and Forecast for 2017. I'm Courtney Stevens, an attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Sonia Valdes and Stubbs, thank you for joining us. Sonia is Vice President of Claims for Medmarc Insurance Group in Chantilly, Virginia. She is responsible for medical device claim investigation and settlement oversight, defense counsel selection, litigation management, trial preparation supervision, and claim reserve audits and assessments. Her responsibilities also include managing Medmarc's staff of claims professionals, overseeing of the claims department practices and procedures, and providing counsel to Medmarc's underwriters regarding life sciences, product liability, and litigation trends. In addition, Sonia has extensive experience in evaluating coverage and liability issues in environmental, mass tort, and drug and medical device litigation. Prior to her position at Medmarc, Sonia served as worldwide claims manager for Chubb's life sciences line of business. Prior to Chubb, she held home office manager positions at Home Insurance Company and AIG. She was also previously employed in private practice, litigating personal injury and employment cases. Sonia is admitted to practice law in New Jersey and is a member of the IADC and ALFA. She received her undergraduate degree in biochemistry from Rutgers University and her law degree from Brooklyn Law School. Sonia is a frequent speaker and contributor of articles on issues of interest to the life sciences industry. Stubbs is a member of the Kansas City law firm of Baker, Sturchy, Cowden & Rice, LLC, where her civil litigation practice is primarily focused on the defense of product liability matters, including the defense of medical devices, pharmaceutical products, chemicals, construction equipment, children's products, commercial-grade fireworks, and various consumer products. Her practice also includes the defense of premises liability matters for a national restaurant chain and various other commercial matters, including the defense of class action matters in Kansas and Missouri. She has served as national and regional counsel to various clients in mass tort litigation. She is a member of the Kansas, Missouri, and American Bar Associations, International Association of Defense Counsel, and DRI. She is a frequent lecturer and author on issues related to product liability litigation. She currently serves as the Vice Chair of the Board of Directors of ALFA International and Chair Emeritus of the Product Liability and Complex Torts Practice Group. She was selected for inclusion in Best Lawyers in America for Product Liability Litigation, Defendants, 2017, and Who's Who Legal Life Sciences, 2016. With that, I am pleased to turn things over to Sonia, who will begin today's presentation.
Thank you, Courtney. Good afternoon, everyone. Thank you for joining us. This will be my third edition of the year that was. I hope you enjoy it. It was an action-packed year. I'm going to flip over to the slide that indicates the agenda. Okay, so we're going to talk about a very hot topic, drug and device pricing. I'm going to lead you through a discussion on that. I'm going to turn it over to Kara for off-label communications. Come back to you on state actions, an area that I spoke about the first year, and it continues to grow in terms of breadth of scope. Kara's going to lead you to 2016 verdicts and settlements. We're going to share FDA activity, warn you about what's on the horizon, and hopefully have some time at the end for Q&A. So I handed in these slides yesterday, the final of the slides, and yet today I got two more articles on drug and device pricing issues. The first one is an op-ed piece for USA Today. A Democratic senator is reaching out to President-elect Trump to try and outline tactics to reduce prices in the U.S. for drugs. And she's got a couple of general strategies which may or may not work, and I'm going to lead you through some of the discussion of the complex issues involved. The second article, and this is just off the printer, is the Department of Justice charged two executives in a generic price-fixing plot. The former top executives of Heritage Pharmaceuticals were accused of plotting to fix the prices of antibiotics and diabetes treatments. That's the first time criminal charges have been used in the generic drug industry. So, one day, two different articles expanding the scope of interest in keeping drug prices down. Okay, so let's talk about the more interesting cases in 2016. The first one is Daraprim. It's a 62-year-old drug. It was the frontline treatment for toxoplasmosis, a life-threatening parasitic infection. The price went up from $1,350 to $750 treatment overnight. This is a drug increase that landed Martin Shkreli, also known as a pharma bad boy, in trouble. Unapologetic, Mr. Shkreli insisted that the increase was needed for research and better drugs with lesser side effects. Bullet number 2 refers to the Mylan Pharmaceuticals EpiPen case. Been hearing a lot about this. In fact, there's another article today about it. Mylan is the sole manufacturer of auto-ejector pens that deliver epinephrine to counteract severe allergic reactions that can be life-threatening. The price went from $57 to $600 for a 2-injector package. The CEO of Mylan is Heather Bresch, who is the daughter of Joe Manchin, the ex-governor of West Virginia. It has been suggested that political consideration kept competitors at bay by erroneously placing the EpiPen product into a category which allowed no substitutions, allowing Mylan to enjoy a virtual monopoly. Unlike other drugs or devices, when a doctor prescribed the EpiPen, a generic could not be substituted. Number 3 you may not have heard of. Rodellis Pharma acquired cyclosporine from the Chow Center, who purchased it from Eli Lilly. This drug is used to treat dangerous multi-drug-resistant tuberculosis. Overnight, the drug price increased from $500 to $10,800 for one cycle of treatment. Under intense criticism from politicians and the public, Rodellis rescinded the price increase and eventually gave the drug back to Chow. Valiant acquired 2 drugs from Marathon Pharma, these 2 drugs from Marathon Pharma, and promptly raised the price of the 2 drugs 525% for one and 212% for the other. Not to be left in the back, hepatitis C. Action was taken against the manufacturer of certain hepatitis C drugs, and I'll be talking more about about this particular case in the state action portion of our discussion. But not to be left behind, generic drugs are also being brought into the fray. There's a new lawsuit against Allergan, Mylan, and other companies for conspiring to increase the price of generic drugs. It's important to know that there are no factual issues that caused these increases. There were no shortages. The increases, in fact, were inexplicable. And there's another strategy to note here. For both the Daraprim and Rodellis drugs, the strategy was to buy old neglected drugs and turn them into high-priced specialty drugs. What about generics, you might ask? Well, there's a lack of generic competition. The reason is that generics usually couldn't get enough of the brand drug to test it and make it their own. The availability of the brand drug was tightly controlled by these entities. And when they finally made it to generic form, it was very expensive because of the cost to acquire the brand name drug to conduct the bioequivalency testing. Okay, so moving on. Why are drug prices so high in the U.S.? There's a few reasons. One of the keys is that the determinations on what drug will be filled are made by the government versus your doctor in Europe and in socialized medicine cases. Other countries restrict the patient's access to newer and potentially more effective drugs to keep the price down. They do a cost-benefit analysis. That is not the case in the U.S. All the patient needs is a prescription from a physician, and Medicare or a health plan will pay for it or a portion of it. Another reason why the drug prices are so high is the FDA approval period is much, much longer than in Europe, and it's more expensive for these companies. Then lastly is a longer exclusivity period for patents, which keeps generics out of the marketplace. And then, I want to conclude with something kind of on the interesting side, I guess, that we have well-intentioned but disastrous FDA initiatives, such as the Unapproved Drugs Initiative. This initiative incentivized drug manufacturers to win clearance for products that had been in use prior to the FDA approval process in 1938 to verify effectiveness and not safety. So they've been on the market, they're safe, they wanted these companies to do testing to verify effectiveness. This has led to price hikes in recent years because the FDA temporarily awards exclusive sales rights to the first company that wins approval of the given drug. That's the incentive, and the sales exclusivity may last several years. This initiative has led to enormous price hikes. For example, pretty innocuous potassium chloride used to prevent a dangerous mineral deficiency called hypokalemia. The price increased from $4.40 to $108 overnight, a 2,067% increase. Colchicine, used to treat or prevent gout, that went from $10 to $500 per unit. And then lastly, vasopressin, an antidiuretic that is important in retaining water in the body and aids in the proper functioning of the kidney. This went from $5 to $140 a vial. So while the FDA thought it was doing a good thing, what it really did was inadvertently lead to enormous price hikes in fairly innocuous drugs that have been around for a long time. Okay, so my next question is, do we really want the government involved in drug and device pricing? I have to say it's a resounding no. This slide, it lists a number of ways the government tries to regulate prices. Some are more effective than others. Mostly they don't work because companies still need to make a profit. If a certain amount of profit isn't there, the companies will pull out of manufacturer distribution, and the government may wind up providing subsidies for the companies to resume production. An example of this would be vaccines. Vaccines are subsidized by the government because they're just not profitable. So what will be the result of the government imposing controls? I think it will lead to shortages and curtail production of key drugs, and it will ultimately cost the government more. Okay, that's fine. So this, I guess, is the most important slide in my presentation. You don't know whether your company is going to be the next one targeted by the government. What can you do to protect yourself? I offer to you that what you can do is to capture and explain the astounding costs and why the price increase is absolutely necessary. And you do that through rigorous and detailed accounting of the cost of the clinical trials, the cost of pre-market approval or any subsequent approval process, the cost of regulatory compliance, such as adverse event reporting to the FDA, or establishing an internal safety surveillance unit in the company, the cost of any recall or corrective action, the cost of the sale of the product at reduced prices. Many manufacturers offer these drugs at reduced prices to Medicaid, Medicare, or government programs. Another way to show the cost of it is investments in additional research to update the product by making it safer, warnings, delivery methods, and last minute, you want to paint the company as a good corporate citizen, what you give back to the immediate community in which the company is located, and what you're doing to give to not-for-profits. So I think those will all kind of blunt the attack on the price increase. And now with that, I'm going to turn it over to Tara.
Thank you, Sonia. So first off, I want to say thank you to Sonia and Medmarc for the invitation to participate today. Very much appreciate the opportunity. And also just want to make a brief disclaimer that the comments I'm making today are mine and mine alone, not those of my law firm or any clients that I represent. And I'd like to start off by talking about off-label marketing and commercial free speech issues. As you all know, there has been a history of tension between the FDA and the First Amendment. The FDA's historical position has been that off-label promotion by a manufacturer is unlawful, even if statements are truthful and non-misleading. And you all will recall two key cases that challenged the FDA's position. One is Carlina and one is Amarin. And I don't want to do a deep dive into those cases. I'll kind of do the thumbnail sketch. United States versus Carlina, it's a Second Circuit 2012 opinion. In that case, a trial court, a jury actually rather, found a pharmaceutical representative guilty of conspiracy to introduce a misbranded drug into interstate commerce based on off-label promotion. The Second Circuit then vacated that conviction, concluding that the government cannot prosecute pharmaceutical manufacturers or their representatives under the FDCA for speech promoting the lawful off-label use of an FDA-approved drug. So in essence, criminalizing off-label promotion would run afoul of the First Amendment. That is Carlina. Then Amarin, this is out of the Southern District of New York, 2015. Brief history there. So in 2012, the FDA approved one of Amarin's drugs. February 2013, they submitted a supplemental NDA. They were looking for an additional indication based on a special protocol assessment. The FDA later rescinded the special protocol assessment and told Amarin that basically any effort by them to market this drug for the proposed supplemental use would constitute misbranding under the FDCA. And you got to love Amarin. They go on the offensive, and in May of 2015, they file a civil complaint. They claim that the FDA's threat of prosecution for misbranding has a chilling effect on their free speech, which is protected by the First Amendment. And they sought an injunction to prevent the FDA from prosecuting Amarin for truthful and non-misleading speech concerning the drug. What happened in March of this year is that the FDA and Amarin reached a settlement. Yeah, I guess I should be clicking along here. And basically, people look to this as erosion of the FDA regulation of off-label promotion. And if you look at this settlement, basically the terms here that are kind of ticked off, these basically track the judge's granting of the preliminary injunction. And you'll see that Amarin may engage in truthful and non-misleading speech promoting off-label use of Vascepa, and under Carlina, such speech may not form the basis of a prosecution for misbranding. The FDA agreed to be bound by the court's conclusion that the statements and disclosures that Amarin proposes to make to doctors are truthful and non-misleading. And, of course, Amarin will bear the burden then of assuring that any communication remains truthful and non-misleading. As you know, science is not static, and that's a bit of a moving target. The FDA also agreed to provide Amarin with an optional preclearance provision that runs through 2020 for new off-label claims, and then there was a dispute resolution provision. So kind of the takeaway here, I think, is, we've got some good precedent. We've got this nice settlement here that Amarin and the FDA reached, but I think we still need to tread cautiously when moving away from approved labeling. So here's kind of a slide I put together of what the landscape looks like today. No surprise, there's no protection for statements that are either untruthful or misleading. I think it is easy to determine if a claim is untruthful, but I think it's really, really a difficult proposition sometimes to know if a claim is misleading or not. So I think that's a potential issue to be wary of. And this is important, too, this third point. A manufacturer that's going to leave its sales force at liberty to have unscripted conversations with physicians regarding off-label use of an approved drug or device, I think runs the risk of a misbranding action if it's false or misleading. So I think those very much need to be controlled and scripted. We already talked about medicine and science as evolving, so that's an issue. And the one thing I think, too, to keep in mind is that the speech at issue in Amarin, it was directed to healthcare providers, not consumers. So that very much is a distinguishing piece. Those two rulings were out of the Second Circuit, but I do want to highlight one opinion in this area that came out of the Western District of Texas in February, United States versus Vascular Solutions. And the reason I want to highlight this is that the jury ended up acquitting the Vascular Solutions company and the CEO of criminal conspiracy to violate the FDCA by selling misbranded medical devices, and these happen to relate to varicose vein treatment. But critically, the judge instructed the jury, consistent with Carlina and Amarin, that speech that is truthful and non-misleading is not criminal. So I think this is a great recognition for the rest of the country that, we've got a court now that's adopting the Second Circuit approach. Okay, so shifting kind of to what I've tagged as the latest and greatest. Last month, the FDA did conduct a public meeting on manufacturer communications regarding unapproved uses of approved or cleared medical products. And I don't want to take a lot of time kind of going into the weeds on this, but I do want to share kind of some key takeaway points. Obviously, Camp 1 consisted of those in favor of easing restrictions on off-label communication. So the cast of characters, of course, is, drug and device manufacturers, third-party payers, physicians, patients, and, of course, there were some free speech advocates in the mix. As far as third-party payers, there was general agreement that expanded off-label communications with third-party payers should be permitted, primarily because it enables them to have sufficient information to develop formularies, and it would alleviate concerns about delays in getting drugs added to formularies. The physician group, they yielded support for more off-label manufacturer communications to physicians, especially in the context of treating patients suffering from rare or pediatric diseases where off-label use is typically the standard of care. With respect to medical devices, manufacturers and physicians alike advocated easing restrictions on off-label communications. The physicians were pretty loud in their voice that they do need that technical assistance to use and program devices, and if there are restrictions in place, that it's going to be a barrier any barrier to assistance rather would result in patient harm, and obviously that's a risk they don't want to take. With regard to kind of the speakers who are in the easing of the restrictions camp, there was consensus that off-label communication should be based on scientific evidence, but the big debate was surrounding, what would that be? Are we talking about something that's peer-reviewed versus anecdotal or real-world experience? So there's some ongoing debate about that. Then with respect to the camp that was in favor of increased restrictions, they pretty much ignored any First Amendment implication and argued that the recent case law, Carlina and Amarin, it was non-binding or wrongly decided or should have a very, very narrow interpretation. They also were very strong in their opinion that reprints of articles have little evidentiary basis. Their feeling is that reprints are not objective because manufacturers have an improper influence over the review process. Felt very strongly that FDA should be a gatekeeper to determine if information is backed by sufficient scientific evidence to be shared with physicians, and they also feel that physicians are going to learn of off-label uses of drugs and devices through their peers and membership organization, so really there should be no need for any off-label communication, which I think is not a strong position. One issue that was very interesting, and I'll close with this, is that there was an issue of informed consent. Some of the speakers who are against off-label communications pressed the FDA for a requirement that physicians would need to obtain a separate informed consent before prescribing a drug off-label or using a device off-label, and that's problematic for a host of reasons, but the primary reason is, of course, that the FDA is prohibited from injecting itself into the doctor-patient relationship. And I'll just note that written comments are accepted by the FDA until the 9th of next month, if anybody on the call has any interest there. Right, Sonia, back to you.
Thanks, Kara. Okay, so I'm going to talk about a topic that I talked the first year I was here at Medmarc. And I'm going to focus my comments to state actions, not federal actions, because I'm really concerned about the evolution of these cases, the breadth and the scope, and how they're evolving the allegations. So state actions that I'm talking about are actions by the Attorney General to recover money spent by the state. They really got their genesis from the settlements in the tobacco industry. The tobacco companies settled with the plaintiffs and then immediately were sent bills by the various states for medical costs and expenses for treating smokers in their state. And they were able to reap very expensive settlements. I call this the birth of regulation by litigation. It does advance policy preferences against certain companies, not surprisingly, pharmaceuticals and medical device companies. These policy-focused lawsuits give the state executive, the AG and the state executive, the ability to bypass the legislative branch to achieve regulatory objectives that they believe are important, that in fact may not be supported by a majority electorate. It's popular for them to proceed against drug and device companies because they cost so much money in terms of when somebody gets injured. The state looks at how much was spent in medical benefits, procedures, or issues with a certain product and wants some relief or reimbursements. And these actions provide a ton of relief for the state. How it works is that the state attorney general hires a private law firm that is politically connected to file suit against the target company. The AG delegates the right to bring actions arising from a breach of the consumer protection statutes and unfair trade practices statutes to the law firm. Now, there are those who argue that this is an unfair delegation of responsibility or authority. These statutes are laws to ensure fair trade, competition, and accurate info in the sale of goods or products. They're designed to prevent fraud and unfair business practices. And more importantly for the state, these statutes provide a very broad range of remedies. So if you're looking at this and wondering how could they possibly delegate that, that is a question that's asked by those who see these actions coming. The worst part of this really is that there is no public oversight of any aspect of this process. So let's talk about the state actions in 2016. I've lumped them into different categories. Opioids is the first category. This country is in the state of a drug addiction epidemic, and you've been hearing a lot of commentary about opioids and the failure to warn about the addictive nature of the opioids. And that's what Bullets 1 and 2, the Illinois AG suing incest therapy, and then New York AG for endo. It's for deceptive marketing and false advertising, not fully explaining or not fully divulging the addictive nature of the opioids. And then the third one's a really interesting one. It's an antitrust complaint by various AGs against Ividor, alleging that it was trying to keep out a generic version of its opiate addiction treatment drug. Now, a summary of those kind of leads you that these are really broad policy objectives in the particular cases, especially the one that's trying to keep out the opiate addiction treatment drug. More traditional is the New Mexico Attorney General going after Bristol Myers for false advertising of Plavix. But the allegation is interesting. It alleges unsafe and ineffective for certain people. There are some commentators who suggest, isn't that what the FDA does, not what the New Mexico Attorney General does? And there are other actions as well. For example, if you think that medical devices are immune from these type of actions or not, this California Attorney General and the Washington Attorney General sued J&J for false advertising, deceptive marketing arising from its surgical mesh products. They claim that the warnings were insufficient regarding potential complications. And then getting back again to the topic that I had previously, drug pricing. 2016 was the first year we started seeing these AGs go after companies for increased drug prices. And the first one's an interesting one. Maryland Attorney General went after J&J for antitrust violations, i.e. they negotiated an agreement with Costco to increase the price of its contact lens products. More traditional, the Massachusetts Attorney General filed an action against Gilead for raising two Hep C drugs, Sovaldi and Harvoni. One was 95%, the other was 84% price increase overnight. Now, the third one's interesting. It's the city of Providence. So you're not even seeing the state, you're seeing a city entity proceeding against Allergan, Mylan, and others over generic drug prices. The city of Providence alleged that these companies entered into unlawful agreements with each other to inflate and fix the prices of two drugs, dioxycycline, an antibiotic, and digoxin, which is a heart drug. And not to be left behind, the UK just last week fined Pfizer £84 million for escalating the price of an epilepsy drug. The price was increased by 1,600% in a very short amount of time. And as the UK medical authority noted, it is important that epileptic patients continue with the same drugs. They don't show the efficacy when you change it from one drug to another. Looking at settlements in 2016 on these state actions, we could only find one. And that's really notable unto itself. It's the Novartis case. They paid $35 million for off-label allegations regarding its Elidale skin product. There have been a number of large settlements in past years. What this signifies to me is that companies are really taking the time out to defend themselves against these cases because they have been brought for the last 2 years, quite a few of them, but yet this year we've only had one settlement. So I think that the companies are finally waking up that there's no end to any of these actions. So what's being brought in these state actions? They're taking a kitchen sink approach. The AG, traditionally, their allegations focused on false advertising and off-label promotion of certain products. Now they've been expanded to include the last five. Numbers 3 to 5, inadequate warnings, inadequate adverse event reporting, and withholding data from the FDA are particularly egregious because the states really are trespassing into the FDA regulatory territory. They're second-guessing the FDA review and investigation of whether or not the FDA should act. Numbers 6 and 7 are also troublesome because they're being done at the state level with no clear appreciation of the regulatory history or the costs associated with bringing and maintaining the product in the marketplace. So 3 to 7 are trends, new trends, and expanding the breadth of these actions. Lastly, I just want to comment, what does the government seek as damages? Well, very broad remedies. Recover the state expenditures for the prescriptions, the cost to treat these individuals, and any civil fines or penalties. So it's been expanded, not just reimbursement of medical, but fines and penalties. So what can a company do to defend itself? First thing it should do is challenge the appointment of private counsel on due process grounds. It's a denial of due process because the state is delegating the government's coercive powers to private attorneys with a direct financial stake in the outcome. Among the coercive powers would be the subpoena powers. The state allows these private law firms to subpoena witnesses and entities. Another defense would be the violation of separation of powers because the executive branch has bypassed the legislative branch, and the legislative branch is what provides the funds. They are paying for these law firms with funds that haven't been allocated to them. So there's a number. Then there are the more traditional ones. The First Amendment right to free commercial speech, what Kara spoke to you about, that some commercial speech is protected. There are preemption defenses. This is the exclusive purview of the FDA approval and process and investigatory powers, and that the state should not be messing around with them in any way. And then lastly, there's a regulatory activity exemption, which is like a safe harbor provision, that the complaint about activity from the company was within the regulatory activity sphere. So now I'm going to turn it over to some really shocking verdicts. Kara, take it away.
Sure. So when I was sitting down to work on the PowerPoint, I got an alert on my computer, and it was this, billion-dollar verdict against DePuy in the Pinnacle Hip MDL. And I thought, well, that's got to be a typographical error. And as we all know, that was not. So this MDL is pending in the Northern District of Texas. This was the third bellwether trial involving 6 California plaintiffs. The jury awarded $4 to $6 million per plaintiff in compensatory damages, and I think maybe the Lawsuit Consortium plaintiffs got $1 million each or something like that. But the astounding component is the $504 million punitive damage award against J&J, and then another $504 million punitive damage award against DePuy. So these are California plaintiffs, so it's California law that applies. There is no cap on punitive damages in California. However, I think everyone has to agree, well, not everyone. I think logic should dictate that the verdict cannot stand. It's just too big of a multiplier. But I wanted to share an interesting story kind of as to how this $504 million figure was likely arrived at by the jury. So in closing arguments, the plaintiff's attorney reminded the jury of J&J testimony related to an $84 million settlement J&J had made to end an investigation into allegations that paid doctors kickbacks. A witness from J&J had said that J&J wasn't admitting to any wrongdoing, but paid the $84 million to make the headache go away. The plaintiff's counsel then, in closing, argued that the $84 million is aspirin money to them, and urged this jury to impose a penalty stiff enough to make J&J change future behavior. And the jury was listening, because if you do the math, $84 million times 6 plaintiffs, you get $504 million. So that is kind of the background for that figure. So we will be obviously watching attentively the appeal of that verdict. There was a second bellwether trial in that MDL that verdict came in at $502 million back in March. The judge did slash that to $150 million. In large part, this was due to caps in Texas related to punitive damages. That verdict, however, is also on appeal. And then I think it's just interesting to note the first bellwether in 2014 was a defense verdict. And from what I've seen, I think about 8,000 cases probably remain in the MDL. The next bellwether is September 2017. The speculation, of course, is that J&J will move to stay that trial pending an appeal to the Fifth Circuit, and then potentially, if that's denied, take a writ of mandamus up to the Fifth Circuit, and they kind of went through those hoops before this last trial, and that was denied. So the speculation is that this next bellwether will go forward, likely with these second and third bellwether verdicts on appeal. All right, now talcum powder verdicts. I'm sure you all have seen these throughout the year, but in these cases, plaintiffs are alleging a link between their talcum powder use and their development of ovarian cancer. And there were 3 trials in our backyard in the circuit court for the city of St. Louis in Missouri, 3 verdicts that were significant. The first verdict was for $72 million back in February. Important to note that plaintiff was from South Dakota. The second trial resulted in a $55 million verdict in May with an Alabama plaintiff. And then the third trial was a $70 million verdict, and that involved a California plaintiff. Obviously, J&J is appealing these verdicts, and based upon what I've seen, I think there are about 2,500 claims pending, with the majority of these in the city of St. Louis, which kind of leads me off onto a tangent, so please bear with me. But I want to give a little time to talk about the City of St. Louis Circuit Court and what kind of has been captioned as litigation tourism. What we are seeing over in that part of the state is venue and joinder run amok. We have in Missouri a permissive joinder statute and a venue statute, And in conjunction, they are permitting these mass joinders of plaintiffs in product liability complaints. And these plaintiffs have nothing in common except they're suing over injuries that are not the same, but allegedly caused by the same product. So we're seeing these larger complaints in talcum powder, pelvic mesh, hernia mesh, IVC filters, and others. And kind of the formula the plaintiffs as far as using is they want to include as many plaintiffs as they can. They are very cognizant of the Class Action Fairness Act limitation of 100 plaintiffs, so they're not going to exceed 100. They look for a single plaintiff from Missouri whose first injury occurred in the city of St. Louis. And then they obviously need a plaintiff from the home state of the defendant so they can defeat diversity. So this is how in the talcum powder cases that you had plaintiffs from South Dakota, California, and Alabama who had absolutely zero relationship with Missouri. And I think it's also a kind of a favorite venue now for plaintiffs' counsel. They've seen these verdicts. They know they can conglomerate their clients together in these larger complaints. But there's two other factors that I think yield to cases being filed in high volume. In Missouri, we have a pretty low bar for admission of expert testimony. And just to illustrate this, if you look at the talcum powder litigation, in New Jersey, the state court judge granted summary judgment in two talc cases, finding plaintiffs' experts, who, by the way, were the same experts that testified in the cases in Missouri. He found that these plaintiffs' experts had gaps in their quote-unquote made-for-litigation scientific methods and failed to explain how talcum powder specifically causes ovarian cancer. And just as a footnote, Missouri doesn't have a Daubert or a Frey standard. We have a statute that drives admissibility of expert testimony. And last year, during legislative session, through some great lobbying efforts of a lot of different organizations, a Daubert standard for expert admissibility was actually passed by our House and Senate, but it was vetoed by our governor. So that was kind of a big fat bummer. The third point I just wanted to make, specifically with regard to the talc cases, and this isn't unique to obviously this jurisdiction. I think it happens all over the country, but in advance of these trials, what we're seeing is basically the jury pool subjected to a very high volume of misleading advertising, and specifically with regard to these cases, these talc cases in the city of St. Louis, the ad campaign prompted J&J to seek another venue, which obviously was not successful. All right, moving on to Riskbased and the Philadelphia Court of Common Pleas, another jurisdiction I know sought out by plaintiffs' counsel. I want to talk about the most recent Riskbased trial, which the verdict came out in July of this year, and this was a $70 million verdict, and that's astounding in and of itself, but I think it's even doubly astounding when you appreciate that that is solely compensatory damages. No punitive damages were awarded. Plaintiff was an adolescent boy from Tennessee who had been prescribed this medication for a very serious a very psychiatric issue, and basically he developed female breast tissue. And so I think it's pretty clear that the verdict does not bear a relationship to the injuries. Clearly, J&J and Janssen are taking this one up on appeal. 2,000 cases remain, I believe, on that Philly docket. At this point, the companies are not looking to globally resolve the litigation. They feel like that fifth trial is very much an outlier. One thing of note, I think the plaintiff that kind of drove the verdict amount was that plaintiff was allowed to argue that the company committed fraud on the FDA, and I think any time you can inject the F word, as I call it, into a trial, I think that always ratchets up any verdict. So that's going to be an appeal to watch as well. All right, we're staying in Philly for this next case, Carlina versus Ethicon. The reason this one was of interest to me is that it's a pelvic mesh case. The verdict is $13.5 million. $10 million of that is punitive damages. But what was astounding about this verdict in the context of pelvic mesh was we saw something that we typically have not seen in other verdicts, and that is that this plaintiff did not have extraordinary injuries or numerous subsequent surgeries, and that's typically what drives up a lot of these verdicts. So plaintiffs were touting this kind of trial and how they conducted this trial as a quote-unquote trial in a box, and they proposed using this as a model for a majority of the pending cases, which are plaintiffs like Ms. Carlino, and they feel like it can be easily duplicated. So they are relying on this trial and trial in a box to try to inflate settlement value, and we'll see if they're successful or not. Okay, now for some good news. I've got 2 defense verdicts I want to talk about. The first is Shearer versus Boston Scientific and C.R. Bard. That was tried here in Kansas City in Jackson County Circuit Court. I was one of the lawyers representing Bard. It was an 8-week, trial spanned 8 weeks. We started the Monday after Thanksgiving and we ended early February. But the plaintiffs were very excited about this trial, I think. It was the first trial in the country involving 2 mesh manufacturers. So, of course, they're going to get to share this corporate bad actor theme and story that they like to parade out there 2 times, and really felt like this was going to be a good case for them. Plaintiff sought $28 million at the end of the day in compensatory damages and was also seeking punitive damages. Ultimately, we got a defense verdict. It was a 10-2. You've got to have nine jurors for a verdict here in Missouri. But what's interesting about this case, and the takeaway for me is never give up on your fact investigation. Discovery may be closed, but there are always those issues that you can't quite chase down. And the takeaway is never give up, because in this case, when we had plaintiff on the stand, she elicited some testimony that was helpful to us into identifying and locating some medical records that until that point in time could not be located, because she testified she didn't recall where a specific procedure occurred or who performed it. And those records were key because they showed that, in fact, years before either of these companies' meshes were implanted, that she had a procedure done where mesh was been implanted during a prior procedure. So that kind of undermined her whole causation theory against these 2 companies, and there was also some other issues that played into that. But that is my takeaway on this case, but that was certainly a nice outcome. The next defense verdict is Deline versus Wright Medical, another Missouri opinion that was in the Circuit Court of St. Louis County, which is distinctly different from the city of St. Louis, which is where the talc cases were tried, night and day. This was part of the metal-on-metal hip implant litigation, and I just kind of wanted to share this one because I think this just illustrates the point that when you have a product liability manufacturer and a healthcare provider coordinating and cooperating, good results happen, and that's what happened here. Neither defendant pointed at each other, and the defense verdict was obtained. All right, I want to spend a little bit of time about settlements that we saw in 2016. The Wright Medical Conserve Hip MDL in the Northern District of Georgia. This was interesting to me because the first bellwether was November of last year, and the jury in that case initially came back with a verdict that Wright's product was not defective, but they still awarded $11 million. So obviously there was a disconnect. They didn't understand. They didn't do it right. So the judge orders the jury to resubmit its verdict form, and then the second shot of filling out the verdict form, they reversed 2 answers concerning design defect, reversed a finding that plaintiff was partially at fault, reduced damages for negligent misrepresentation, yet they increased the overall compensatory damages and quadrupled the punitive damages. So the whole thing was just very interesting to me. At the end of the day, the judge did end up reducing that verdict to $1.1 million. And then you'll see a year later, November of this year, Wright was successful in settling about 1,300 claims for about $240 million. There is a subset of claims, about 600, that are not part of that, but I guess there's a subsequent settlement program in place. Some commentators observed that factors that contributed to what is viewed as a really good settlement for Wright is that the plaintiff's bar recognized that Wright was a smaller manufacturer and didn't have the insurance and the amounts of other larger manufacturers, and also recognized that Wright had litigated against its insurance company regarding the nature and extent of coverage. One other settlement is the Sentience settlement. That's another MDL. It was in Massachusetts, and in this one, plaintiffs alleged that the company concealed knowledge regarding certain components that are produced in the body after taking 2 different dialysis drugs that eliminate too much acid and can create an imbalance that causes fatal heart attack and stroke. And kind of the genesis of, I think, this litigation was a recall issued by the FDA. It was a Class 1 recall based on false and misleading advertising. You'll note they settled it in February of this year before the first bellwether trial began, which is interesting timing. But I just wanted to highlight this one. I think it's obviously the message we all know. If there's a recall or a warning letter or some kind of FDA action, we can anticipate litigation, will follow. And then I wanted to end on just a couple of settlements for AMS and Johnson & Johnson and Ethicon involving pelvic mesh. Obviously, these litigations are winding down for certain defendants. I think AMS very much so. I think Johnson & Johnson and Ethicon still have quite a few lawsuits out there, but hopefully in this next year that litigation will definitely wind down.
Okay. Hi. We're going to start talking about the FDA activity, generics labeling guidance. And I'm going to talk to you about the long-awaited generics labeling guidance. The FDA has been promising this since 2015. It's now been postponed to 2017. I would not be surprised if it were postponed again. It's very much a hot-button topic. The revised generic drug guidance would allow generic manufacturers to change labeling so that it does not match up with the brand name drug if adverse events. Their collection of adverse events suggests that there are certain side effects that are not present in the brand drug. This would require generic companies to perform post-marketing surveillance and testing and increase reporting to the FDA. There's a number of things that are wrong with this, but the plaintiffs' attorneys are livid over the fact that if you take a brand name, you have a right to sue. If you take a generic, you don't, for failure to warn and design defect. So they've been impressing that, the drugs are supposed to be the same. How come you have a right to sue under one and not on the other? But I will tell you that despite their arguments, which were getting some traction with the FDA, public policy considerations may be more at the forefront of all of this. If you were to require the generic drug companies to do this post-market surveillance and testing and increase reporting to the FDA, this would be such an expensive undertaking that it would drive the cost of generics through the roof. And is that what you really want? When you look at the Affordable Care Act, Medicare and Medicaid all have reduced drug prices as a result of the generics and negotiated discounts for brand name drugs. Healthcare continues to be an issue. The availability of generics is a way of fighting the healthcare costs. And so the question becomes really is what is the administration going to do about it, the new administration? Is it going to pursue what plaintiffs' attorneys want to do with it, or is it going to continue to insulate generics companies? Sitting here before you, have no idea what's going to happen. I doubt, frankly, anything's going to happen in 2017. And I am hoping that nothing happens with respect to the rights and responsibilities of generics. I would like to ensure that they stay at a minimum cost. And so I'm going to turn it over to Kara, who's going to talk about a very interesting guidance on cybersecurity.
All right. So the FDA issued a draft guidance document for post-market management of cybersecurity and medical devices. And you can read here what the objective is. It's to provide manufacturers with structure and specificity in their mission to counter threats to patient safety in their three major areas of concern: risk assessment, remediating and reporting vulnerabilities, and also the elements of an effective post-marketing cybersecurity program. Now, I think what was most interesting to me, I was talking with one of my partners just last night, and he had just come back from a cybersecurity meeting and had lunch with an FDA employee and the woman that was making a presentation as well. And you all may be in the loop on this, but I didn't have a lot of detail, but I do now. But the scenario that you're seeing kind of in this under the cybersecurity umbrella is that a white hat hacker will purposefully seek to identify vulnerabilities in a medical device. They will share the vulnerability with the manufacturer. And then they seek money from the manufacturer to find a solution. Some, of course, are more sophisticated than others. Some will threaten to go to the press, Reuters and the like, if the company does not retain them or work with them on some level. And, it sounds distasteful. It smacks of ransom to me. I just feels wrong. But it's the world in which medical device manufacturers live in. And at this cybersecurity meeting, Suzanne Schwartz, who's the Associate Director for Science and Strategic Partnerships with the FDA, she was encouraging manufacturers to collaborate with the white hat hackers and gave very high praise to those manufacturers who are doing that. Obviously, collaboration necessarily entails waiving the right to sue. You can't sue the hacker. 2, you got to pay them some money, right? That's what they want. They want to collaborate with you and help you find the solution, but they got to make some money. And it's noted, too, that smaller companies probably are not going to be very comfortable with the approach because the risk is greater for them. So the advice from the FDA is to analyze the risk identified by the hacker, sit down with them across the table, determine if the threat is legitimate and real, and then work with the hacker to eliminate the vulnerability. Of course, if you go down that road and the cost is too great, then, I think that the manufacturer needs to, retain someone else or bring it in-house or make another decision. And then with the less reputable hacker who is going to threaten to go to the press pretty much out of the box if his demands or her demands are not met in a short time frame, I think in that instance the company's got to control the message and issue its own press release regarding the vulnerability. And, of course, it goes without saying that the company needs to report the issue to the FDA so that consumers can be informed. The agency here, this last bullet point, they're leaving manufacturers significant leeway in developing their own cybersecurity policies within the framework of known and accepted industry standards. So, interesting stuff. All right, Sonia, back to you.
Thank you. I'm going to talk about another important guidance, and this is for 510K products. It was released by the FDA in June of 2016. The aim of this particular guidance is to maximize patient benefits, reduce patient risk, and improve medical device quality. It's designed to educate manufacturing companies as well as healthcare provider. And this particular slide just tells you who is subject to this guidance and who isn't. The conclusion is that this guidance is designed to complement, not supplant, other benefit risk guidance that was previously issued by the FDA. And so what the FDA is really doing in this guidance is telling you what to look for as a medical device manufacturer. Look at the benefit factors. It's the type of benefit, the magnitude. Then balance that against the risk factors, severity, the likelihood, non-conforming, false negative. It's spelling out things that you should look at. And then additionally, facts such as the uncertainty, detectability, and failure mode of regarding the farm compliance history. All of these are issues that every company that manufactures a medical product or medical device that has gone through the 510K needs to look at. I'm going to turn it over to Tara again for some software discussion.
All right, so FDA has issued a draft guidance on software as a medical device. I'm just going to refer to that as SAMD because it is much easier. But the draft guidance was prepared under the auspices of the International Medical Device Regulators Forum, and it pertains to the conduct of clinical evaluation at SAMD and focuses on the general principles of clinical evaluation, which includes establishing the scientific validity, clinical performance, and analytical validity for an SAMD. This draft guidance is intended to provide a globally harmonized environment of when and what type of clinical evaluation is appropriate based on the level of risk of the SAMD. So I was struggling a bit with the definition of an SAMD and kind of what would meet that definition and what would not meet the definition. So it's defined as software intended to be used for one or more medical purposes that perform these purposes without being part of a hardware medical device. So these examples include software that would allow a smartphone to view images for diagnostic purposes, so, think an app. Software that processes images from hardware medical devices for aiding in the detection of cancer, mammograms and the like. Software that provides parameters that become input for a different hardware medical device or another SAMD. It would not include software that drives or controls the pumping of medication in an infusion pump, software that encrypts data, or software that basically is just clinical communication and workflow. It would not apply to that. But it imposes a risk-based category framework. There are 4 categories based on 2 factors. One is significance of the information provided by the SAMD. The second is the state of the healthcare situation or condition. Curiously, the categories are not FDA, MDA classifications or PMA 510K status, and the draft guidance doesn't explain how it's supposed to work with the FDA regs and the medical device classifications. And I think that lack of detail is going to be confusing for manufacturers. I looked at a lot of the comments, and I think many of the commentators have identified these issues, so hopefully the FDA will provide some clarification. But there is a clear focus toward observed real-world performance as part of post-market monitoring, which is really unique to SAMD when you compare it with other medical devices where you have a real-world experience that is really difficult to track. And I just note that the 60-day comment period ended yesterday, so we will wait for more to come on this draft guidance.
Okay, so now we're on the slide you all wanted to hear. What's on the horizon? What do CARA and I see as potential problems going forward? I'm going to talk to you about the first couple of bullet points and then move down to number 6. The first one is continued litigation tourism. California and the Pennsylvania mass torts are going to continue to be a problem, as will litigation in the St. Louis courts. They'll be busy, and the reason they're going to be busy is because of existing case law on jurisdictional approaches, which once an action has been brought in these jurisdictions, chances are very good that you will not be able to get out. And in fact, there's a case that California, that was appealed from California all the way to the United States Supreme Court. The Supreme Court ruled against California, and California took it up on the Superior Court in California and found excuses to get around the Supreme Court ruling. These jurisdictions, California Consolidated Coordinates Proceedings, the Pennsylvania MDL, and St. Louis, will probably continue to be on the judicial hellholes list. The second one, increasing state actions. I've spoken to you about them in my part of the presentation. They will continue to be filed, particularly with respect to the opiate drugs, but also with addressing antitrust and price fixing. That's getting to bullet number 6, the potential removal of barriers to entry. They're going to try and bring in products that are cheaper from other countries, but that is a problem unto itself. It's one thing to look at Canadian products. It's another thing to look at products from the third world or another country that may not have as rigorous a regulatory scheme as we do. Healthcare costs are going to continue to be spiraling out of control. Any attempts at reimbursement via the state actions is welcome. And then they're going to try and any efforts to control healthcare costs are going to be at the forefront of any discussion on these actions. So I'm turning it over to Kara for her thoughts.
Sure. So I want to kind of merge the third and fourth bullet points there, the challenges regarding punitive damage awards, new case law, and renewed efforts with tort reform, because I feel those kind of go hand in hand. I think when we look at the verdicts we saw in 2016, we had a lot of high punitive damages awards, and obviously we've got a lot of appeals that are pending in key jurisdictions, so those will be very important. But I think there's this other component, and you know, I'm going to direct my comments to Missouri because it's very dynamic right now. So we have this renewed effort with tort reform in Missouri. We now have a Republican governor. We have a majority, Republican is a majority in the House and in the Senate, so it's ripe for tort reform. And we need it desperately based upon what we're seeing in the city of St. Louis. And just to kind of emphasize that, as part of this, Sonia and I were talking about the judicial hellholes list, and I pulled it up, and I had recalled that Missouri was number 4 on this list for 2016, and then I wanted to know when the 2017 list is coming out. Well, it's coming out tomorrow, and there was this little teaser at the top that said there's a rumor that a jurisdiction in the Midwest is going to move to the number 1 spot, and that's got to be the city of St. Louis. So with regard to tort reform, at least in Missouri, I expect to see a renewed effort to get a Daubert standard in place so that our judges truly can perform that gatekeeper function. I expect to see an effort to address the joinder venue statutes that have basically opened the door to the mass tort filings that we're seeing in the city of St. Louis. And then Sonia tells me all the time I'm too optimistic, but I'm also hopeful that we'll maybe see some caps on certain categories of damages. I think that's going to be a tougher row to hoe, but I think it's still on the landscape. But for the foreseeable future, at least for 2016, I think you're still going to see these big mass tort cases, not only in Missouri but Philly and California, like Sonia talked about. Moving on, talking about continued focus on cybersecurity issues with medical devices by the FDA and with litigation. I think this area is rapidly evolving. It's definitely on the FDA's radar based upon the draft guidance and the recent comments made at meetings as early as last couple of weeks. I think that medical device manufacturers have to expect contact from white hat hackers. They're on the move, and they're coming to your neighborhood, and they are here to stay.
Okay, so that leaves our last topic, which is potentially problematic products. And I'll start off the discussion by listing a product that I think right now we're looking at contamination issues, but may grow to be a mass tort. And what I'm talking about are heater-cooler devices. These are non-sterile devices that are commonly used during cardiothoracic surgeries as well as other procedures to control patients' blood temperatures. The device works by circulating temperature-controlled water from water tanks through closed circuits to heat exchangers or blankets. The water circuits are physically separated and not intended to come in contact with the patient. However, recent studies have suggested there is a potential for waterborne bacteria called non-tuberculosis mycobacteria to contaminate the surgical setting and ultimately the patient. To date, there have been 79 cases of infections and 12 deaths reported to the FDA since 2010. In addition, this heater-cooler unit, also a different type of heater-cooler unit, helps keep blood and organs at temperature during surgery. These devices have a water reservoir where bacteria grows and can be emitted into the air in the OR. These devices have been available in the United States since 2006, and currently there are 2,000 devices available in the U.S. This is a risk that we are closely monitoring here at Medmarc.
All right, and I would just add to kind of that list of potential problematic products, I would say any device that is vulnerable to a cybersecurity attack, insulin pumps, cardiac pacemakers, and the like. I think that's definitely got to be on the radar. And then just taking a look as to kind of cases that are gaining momentum in the plaintiff's bar and efforts to, seek an MDL. Proton pump inhibitors, I know, are on the verge of finding an MDL home. That will probably happen in March.
Okay, that's all we had on problematic. We have products. We have a couple of minutes for questions.
Great. We're going to now begin the Q&A session. If you have a question, please feel free to submit it using the Q&A panel located at the bottom right of your screen. After typing your question in the space at the bottom, hit the send button. Please be sure to direct your questions to all panelists in the Ask menu. Your questions will not be seen by other members of the audience. So it looks like we have had a few come in. A lot that came in, you ladies subsequently answered in your presentation, so that was helpful, but we'll start out with this one. With Trump's presidency, what effect will that have on drug pricing? Can you speculate as to what his policy might be in that regard?
I'll take a shot at it first. He has mentioned that he wants to work on controlling the cost of drugs, but that is a very complex equation, and you're going to stifle innovation, you're going to stifle research and development if you try and do that. It's not as easy as saying you're going to control it, and it requires a lot of effort. There's a lot of things we do after the product is at market. Post-market surveillance that costs companies a lot of money. And I know President-elect Trump is very serious and diligent about addressing this issue, but I question how far he's going to get, if anywhere, with attempts to control drug pricing. What do you think, Kara?
Yeah, no, I agree. I think he's a really tough read. I think I've seen him make comments on both sides of this issue, so I think it's kind of a hold your breath and, watch.
Okay, thank you. Another one here. What effect does state activism have on defendants? Does a potential state action put pressure on defendants to settle litigation?
I'll start at it first. I think it's a terrible thing reputationally for a state to move against a defendant. The court of public opinion is against them. It's not like a private action where, but now you're saying the state AG has sued X, so they're already being put as the bad character. And it's an intense amount of public pressure on the defendants to settle litigation because, the question because whether people are going to buy their products as a result, is it going to be viewed as unsafe? So I think that's frankly just it's almost like state-sponsored blackmail against these companies because you really are from a disadvantage trying to defend yourself in these cases. And the problem with it is you settle one case and another one gets filed. So, Kara, you want to opine on that?
Yeah, no, I think absolutely that the potential state action would put pressure on a defendant, to settle. I think it's just, one more straw on the camel's back, and I think you've got to, as a defendant. I look at some of the average wholesale price litigation and how some of that litigation was handled, and how that could influence, how companies handle, similar related issues, and I think it does influence without a doubt, and I think that's the lawyers retained by the state are plaintiffs' lawyers, so I think it's all kind of a game,
Okay, I think that's all the time we have for questions. If you submitted one that we didn't get to, we will try to address it offline. Thank you, Sonia and Kara. I know this is a webinar that everyone looks forward to every year, and I'd say you guys definitely delivered us some great information, so thank you.